Good morning, members. I call to order the meeting of the Bills Committee on Occupational Safety and Occupational Health Legislation Bill. We have reached the appointed hour, and this is the sixth meeting. We have the Undersecretary, Mr. Ho Kai-ming, and his team with us. We would like to follow up on some of the issues raised last time. Members raised some issues on the 1st of October at the meeting of the Bills Committee. We have got a response in relation to our issues in CB 287120222-01, and the response is CB 2887/2222-01. And members, having considered the paper CB 2887/2022-01, paragraph 4, and members' views, the administration has agreed to, in respect of section 39, capital A, bracket 4, to make an amendment in the year where the relevant crime was committed. There will be a change in the wording, and then the corresponding consequential amendments will be made to clause 13 and clause 86. There will be further amendments in the form of a CSA to be introduced by the government. Mr. Xiu Kao-fai, last time I raised a question about Section 20, bracket 4, and that is the amount of the penalty will increase from $10,000 to $100,000. I asked whether there were many such incidents, and that's why there was a need to increase the penalty to such an extent. So how many cases have there been? And what's the highest penalty imposed in the past? I'll ask my colleague to respond to this. Well, there is a summary in the response setting out the summonses issued in the past 5 years. And it shows that there's no conviction on the question of water supply in the annex. Well, so what's the justification? I thought it was because there were many people committing such an offense. Well, if your question has not been answered, then you can just say so. But if you want to ask for the reasons for increasing the penalty, then we are going back to the past issues raised in the last meeting. We would further elaborate in due course, says the Undersecretary. Mr. Chen Xiu-hong, I'm grateful for the response from the administration to the questions and issues raised last time by members. There are two parts in that response. One is in writing, which is a framework response. But what is more important to me is the paper with more than 100 pages concerning the proposed fines and also the fines imposed in the past, and also setting out the in the paper the rationale of increasing the penalty levels, because we are talking about more than 600 items. Some are going to get an upward adjustment, some are going to get a downward adjustment. So it's important that we need to know the legislative intent behind such amendments to the penalty. We want to send a very clear message to the industry and other stakeholders that we want to make sure that the penalties are good deterrents, but it doesn't mean that if the penalty is adjusted downwards, then it's a piece of good news. I don't think so. Maybe there has been no prosecution for that particular offense, or from the experience of the past 20-odd years, we have come to the realization that the penalty is not very relevant. That's why we want to make a downward adjustment. But what we want to see here is to achieve consistency, because Mr. Siu Ka-fai has been talking about drinking water rather, because if it's whether it's hot and no drinking water is provided, then it could lead to heat stroke and other serious consequences. But it is a serious problem in the construction industry, and therefore the Bureau would like to impose heavier penalties based on past prosecution. If that's the case, I believe members would all support and unequivocally support the amendments. Well, the table itself is very useful, but I do have a logical problem with the contents. If I may, Chairman, I would like to just use an example to illustrate this. In clause 4, bracket 4, and that is Annex 6, page 2, 6B3, employment, employed in an industrial undertaking and without reasonable excuse commit certain act which may harm himself or another person, or render the environment unsafe. So it's going to raise from $50,000 to $150,000. And the explanation over here is that there were two past convictions. It's a prosecution based on summons. And also page 55, 6B, section 29, clause 29 in relation to section 69 of the ordinance, and that is construction workers without reasonable experience, without a reasonable excuse, deliberately commit an act that may jeopardize himself or other person. So there's no change to the penalty, $50,000. But for 6B2, it would go up from level 5 to $150,000. So I want to know the logic. Chairman, don't misunderstand me that we are going back in our discussion. We are actually moving forward all the time. From the very beginning, as Mr. Siu Ka-fai has told me before the meeting, let's picture ourselves in the first Bills Committee meeting. We were all puzzled, not because the Bureau didn't explain things clearly, but we're talking about many laws here and many different penalty levels. And we were unable to understand the logic and the legislative intent behind all those amendments. And now we have this Annex 1, which set out in a clearer format, and that will facilitate understanding of stakeholders. And also, we want to make sure that the message of a deterrent is getting across very clearly. So perhaps we can use this as an example. Actually, there are other instances, but I just used this particular instance and invite the administration to offer us and explanation, and I believe it will facilitate our scrutiny of other issues as such later. Well, actually, we are already in the cross-by-cross examination stage. I will be responding to those issues raised when we return to cross 29 later. Okay, maybe the Bureau can do this when we proceed to that particular cross. Yes, Mr. Chan? Yes, I know we were on cross 69 and we're now sort of moving back a bit. Well, we raised some questions when we did the cross-by-cross previously. I just want to clarify that if we ask questions when we did the cross-by-cross, also, of course, some crosses were not controversial, and no question was raised, and you may take it that we support that particular clause. But if we are not happy with a particular clause and we want to seek supplementary information, then I believe we should go back at some point to that particular clause, especially when we have raised some point on the rationale. Well, we are not actually passing the clauses. It's a scrutiny process. We are scrutinizing the clause one by one, and then we will, of course, proceed to the next clause once the previous clause is scrutinized. Of course, our members can raise questions or offer comments or seek further written response from the administration. But I have to stick to our order, because otherwise the process can never be completed. Because the reply from the officials might not be entirely to your satisfaction, or you may think it's not at all clear and straightforward. So I believe the only course of action for members in that case would be to raise them again on other channel, on other occasions. Well, I can allow Mr. Ho-Kai-Ming to say something now, but I don't agree with what he has said. When we discover some issues, it's not that we are not allowed to raise the question later. But if they have an answer for my questions, then it should be offered, and then that's the end of the matter. This Bills Committee is set up for purposes including clarification of issues. So apart from providing a written reply, well, I then raise a follow-up question. And you are saying that there's no need to reply. Well, I think that will only lead to amendments raised by members at a later stage. I don't think that's the practice in the past when we did the cross-by-cross examination. Sometimes the Bureau would also propose to move amendments, and not just for this term of electrical. For example, the other bill concerning the precious metal worth $120,000. And the Bureau has already agreed to move an amendment. Otherwise, a lot of resources will be wasted because all the relevant businesses will submit reports and go through all the troubles. I want to move forward quickly, so do I. I think you want to move forward quickly, so do I. We all want to complete the mission quickly. But we have to do a serious scrutiny. I have no problem with longer meetings, even if it's up to 12 midnight. But let's not brush aside the real issues for the sake of speed. Thank you, Mr. Siu Ka-fai, for your comments. But of course, for all Bills Committee, it's always that some members will find that they would need to say something at the end of that process. But let's move to that particular clause and answer the questions.
And if the progress is affected, that's not good. But I know you will have good judgment. Where it is very obvious, where it is very critical, these issues, I will allow time for discussion. But just to remind everyone that we should not unlimitedly continue with discussions going back to various clauses and therefore not making progress. Now, let's go back to the clause by clause. Chan So-hong, do you want to speak? Yes, Chair, just a point of supplement. Now, we want to release a message to society and the stakeholders of this ordinance that we do not want time and time again for the chairman or for others think or feel that we are unreasonable in revisiting issues. We already understand that. But the progress has to be respected. You have already said that already just now. You're repeating yourself. So let us go back to the process itself. Chair, just one other point. Because the lower Kwok cannot be here today, despite him really want to be present today, concerning the detailed information that we are seeking, he is in favor of that. Apart from the point taken up by Siu Ka-fai about potable water, there's another point which Mr. Low is not happy about, is that it is overly subjective on the potable water point. And there is another point on another point concerning penalties that was raised in the meeting last time. We feel that, and Mr. Low also feels so, that the point was actually outdated. Now, where there are outdated information, we would want to discuss those. For example, is a British system still to be unquestionably respected? Perhaps not. There should be due discussion. So if we're talking about just raising or lowering the penalties, if that is the defense, then that is not sufficient because we need to talk about the content, not just the amount of penalties. Well, I think in that case, there are certain aspects which need to move with the times. I think the new new term of LegCo can definitely accommodate more discussion on these matters of principle. There will be occasions and room for that. Well, thank you for the opinions and raised last time. And we have now the Appendix 1, and we now go to the summary, and that is the relevant page under Appendix 1. Now, first of all, on the construction site, Cap 59. First of all, any contravention of 69 is to be, the penalty is to be raised from grade 6 to 9. And so this is on page 55 of the summary. You can find it on page 55. Yes. Thank you, Chair. I have a question for the authority. Why are workers, why is it grade 5 applicable to workers without any change, but it is increased for employers? Well, the answer is, Mr. Chairman, where there is no reason for the worker to cause harm to himself or to his co-workers. Right. In answer to the question, why for workers it is retained at level 5. Thank you, Chair. Thank you for the question. For the penalty levels, there are two aspects from which we can consider it. First of all, employer's contravention. Secondly, employee contravention. For the former, it is very serious or light. Same for employees. As for the penalties, they would be different for each level. For employer's contravention of the law, where it is light, according to the amendment, it is level 4 penalty. If it is a serious contravention on the part of the employer, it is level 6 after amendment. If it is very serious in contravention, then it is $400,000. Chair, he doesn't have to read the legislation out to me. Now, for contractor and worker, their responsibility should be the same at level 5. That's the original legislation. How come after amendment the employer and the employee will have different levels? Now, for a contractor, why would he be given a heavier fine compared to the worker? This is after the amendment, but it's not the case before the amendment. Before the amendment, they were the same. If they have the same contravention on the construction site, why are they treated differently in terms of penalty? If you are here to provide a deterrent effect, then it should be as before. The penalties should be the same. And if there should be any raising of penalties, they should be raised at the same magnitude. This is a very serious fundamental principle. Well, thank you for the question. In considering the maximum penalty, the consideration is a difference between an employer and an employee. We have looked at overseas experience, and we see in this ordinance, the employer is in the prime position to protect the safety of the employees and workers. So even with the contravention of the same clause of the ordinance, the employer's penalty would be higher. I totally disagree. So you're talking about the major employers in your consideration. What about small to medium-sized employers? Of course, for the big and well-funded employers, that's different. But in Hong Kong, what about small businesses? Some employers are very small for electricals and water supplies, etc., and you are pinning them down unduly for with this penalty increase. Well, in general, the employer's capability financially would be higher than the employees, and therefore in considering the penalty level, we have taken this into account as well. Chan Chung-Hong? Now, the point raised by our fellow electoral member just now, I agree to. If you only take care of the point that the construction company would have more means, and the penalty should therefore be higher for them, that may be understandable. But for some subcontractors, they are smaller. Maybe it is the financial capability is more or less the same as that of the worker. It is possible. So I'm not happy with the answer of the authorities. And also, Chairman, I have raised a question just now, and Mr. Ho had said that at clause 29, there will be discussion of my point. Now, I'm worried about that. I'm worried that my point was not addressed when discussing clause 29 just now. Now, I am looking at section 69. For employees, it is retained at level 5, penalty $50,000. But if you look at page 2 of the appendix, if you look at 6B, bracket 3, it says that under cap 59, if there is no reasonable defense where the employee causes any danger to himself or to others, for that kind of offense, the employee attracts a fine of $150,000 from increasing from $50,000. So that contrasts with what we are looking at in 69, section 69. I mean, when it comes to construction sites, it is $50,000 for employees still. So my question is, how do you come up with this kind of discrepancy? What is the logic behind that? Mr. Ho? Yes. My colleague will answer the question. Chair, let me supplement. 4 bracket 4. It refers to 6B bracket 3. That is a general responsibility. The ambit of that is much wider. As for section 29, the coverage is much narrower. It refers only to construction sites. So they are different things. One is a general liability or responsibility. The other is a specific section with specific reference. So they are different, and the levels of penalty are different. Now, Chair, I have a question. Where at the construction site there is an employee who causes harm to himself or to fellow employees intentionally, then would you prosecute on construction site clause or on the basis of the industrial clause as well? Well, Chair, we will look at the specifics of the case itself in considering prosecution. At the appropriate situation, we will use the general application clause. Chair, in that case, I'm concerned the stakeholders of this ordinance, what is important for them is clarity. If you have 150,000 and then again at 50,000, and we're talking about deterrent effects, do they refer to 150,000? And if you say that for construction site scenario, you don't have to change or revise upwards the penalty 20 years ago and 20 years hence today, where there is no reasonable defense, the person is causing harm to himself and to others, the penalty is still $50,000 changed, then I think the message you send is very important. In the construction site, you have not increased the penalty, but in the industrial site, you have increased the penalty. And we know that in a construction site, the dangers are higher, the risks are higher. There are big construction sites and smaller construction sites. But where the employer or the employee causes others harm, it is a grave situation. If you say that for employees you do not have to raise a penalty, then I actually do not understand the reason why. Mr. Ho? Chair, I understand the question. When we consider the penalty, we also consider the case. When we make the prosecution, we will look at the case itself. In general, we will use the first clause, that is 6B3 for prosecution, for general situations. Chair, I do not understand the argument. You're saying that the employers of the construction site, that is a contractor, will have a bigger financial responsibility. But maybe I haven't been reading the clauses differently, but I've gone through that 30 times. I mean, the only difference between the two sections is just the difference of the construction site. So what are you trying to achieve? What is your logic? Are you trying to make contractors self-employed? Are you driving them to that route? I mean, what it is now is unreasonable, especially to SME contractors, those who come up to a house to change a light bulb.
處理呢個第一個問題。
So how are you going to deal with this discrepancy? Well, in 1981, 1994, we have 2 rounds of amendment, and now this is the 3rd round. There was no amendment to this particular provision in the last 2 rounds. Why do you want to raise the penalty on the part of the contractor this time? Well, our principle is that we would categorize offenses as serious and minor. For employers, and you can see that the relevant principle is applied here. For employer, the penalty is $100,000, and employees $50,000. Well, it's not we favor employees, but we just want to maintain the consistency, and of course there is the level of responsibility when it comes to general provisions. We're not favoring one over the other. Mr. Louis Leung, Chairman, let me also say something about the general responsibility provision and the incident-related provision. I think the two should be regarded as the same. General provisions mean general responsibility means that it applies to all incidents. But when it comes to individual incidents and you say the responsibility is lower, I just don't know whether it's really consistent, because it seems that you can choose to apply either one. I think we should align the two levels, two kinds of provision. The basic principle is as what I've said. With regard to Mr. Leung's comment, general responsibility, why a heavier penalty is imposed regarding general responsibility provision. Of course, if we want to ensure industrial safety, we want to see that there's no industrial incident. But of course, we can check the legislative intent in the past. But this is just a question of categorizing the seriousness into levels. When are you going to invoke the general responsibility provision? And when are you going to invoke the industry-specific provisions? I think Mr. Leung is asking for the standard that you are basing on. I know you have some custom or practice here in drawing the line. Well, I will provide a written response after the meeting. So when are we going to have general responsibility imposed? Well, if the circumstances of the case are serious, then we would invoke the provision on general responsibility. For specific responsibility, it's generally speaking, the case is less serious. So for serious cases, general responsibility. For less serious, for example, not fatal, not seriously injured, then the other provisions will apply. Yes, I've heard the explanation, but I just don't find it acceptable. I hope the Bureau would align the two, general responsibility and specific responsibility. Mr. Chairman K. I have to declare my interest. I'm a lawyer, and I represent both employer and employee, and I've heard the answers given. I don't know whether it's a problem with how you personally understand the law. From my practice, I don't see the line that you have set for law-abiding people who would like to know where the line is. They cannot find such a line. You say serious case, then it's general responsibility. Otherwise, a specific provision. Can you back up what you claim with statistics? My practice experience is that both will be invoked. You would prosecute both under general responsibility and specific responsibility. But then when it comes to sentencing, the judge would just apply the totality principle in sentencing. But we are in a legislative council meeting. We have to be specific and precise. We don't know where the line is. But you have said something, but I don't see that it's the line applied in case law. Or I have not heard judges offering such observations in the judgment. But we have to be very clear about this. That's why I have to ask these questions. Assistant Commissioner, perhaps we can further elaborate through a written response. And that is without reasonable excuse, Worker Commission Act, which may cause injury. We will not use both sections here at the same time. And then we would apply general responsibility in the prosecution, but we also invoke other specific sections. For example, construction site safety or other laws on, say, cranes. We would prosecute in accordance at the same time. We will invoke other provisions at the same time in the prosecution, but we will not invoke Section 69 as well. So that's by way of clarification. But can we further explain when general responsibility, or say 6B3, and when would Regulation 69 be applied? In order not to impede the scrutiny, we would provide a written response later. I'm not saying that you would use 6A and Section 8 and 6B at the same time, because they do not have dual capacity. but you will use 6A, invoke 6A plus other provisions, or 6B plus other specific provisions. So I agree with the concept of increasing the penalties, but you have to consider the cumulative effect, because for one industrial accident, you can invoke 10 or 5 sections of regulations in your prosecution. But the judge does have a wide discretion in sentencing. Mr. Tang Fei. Thank you, Chairman, Commissioner. The amendments are mainly related to factories and industrial and construction sites. But schools are also regulated by these laws. Many members ask a question about the general and non-general responsibility. However, there are many instances. For example, 68. When are you going to use summary prosecution? When are you going to go for indictment? And that's related to questions of general. And I don't know whether non-general is a proper term. Every year, the Education Bureau will issue an administration manual to schools. One chapter is on occupational safety and health. And we have to follow the occupational safety and health guidelines issued by the Labor Department, and the school might have labs or workshops. They have also got a ventilation system installed, etc. But this document is dated. It was published in August, the year 2000. Well, they're still using the same edition. The Education Bureau is using a bureau. Are you going to amend this particular set of guidelines to move ahead with the times? When are we going to go for summary prosecution, and when are we going to go for indictment process? If it's a very serious offense with serious consequences, then we go for indictment. Otherwise, it's a summary prosecution. That's point number one. Second point is about the guidelines. We would review the guidelines in a timely manner.
局咧就通知翻。
Oh no, please inform the Education Bureau that the guidelines are really outdated. Actually, the title of the guideline is now different. Chairman, I want to be succinct, but this has to do with a very serious legal principle. If this is how Regulation 69 is worded, then we have two different rules for punishment. One for those with better means, one for people with lesser means. Well, then how can we do justice? As you can see, the goddess of justice in front of the courthouse is blindfolded. We should have the same yardstick for people of different description. So perhaps the Department of Justice should be invited to explain how this is justice. Well, this is about construction site safety with very detailed provisions. Many cases will rely on 59I. Can the department tell us how many cases there were in the past 5 years related to 59I? And don't think that they are all big construction projects. Even in schools, you you can have projects falling under the definition of 59I. We have to make sure fairness and that the same principle is applied to all relevant projects. I said this is not a logical categorization. You do something in respect of contractors and some different things with employees.
Let's say a contractor, he puts in all the safety measures, but on the other hand, the employee doesn't abide by those measures and therefore caused harm to others. Why is the employee being fined less than the employer? So there are those measures put in by the employers, but the employee doesn't follow the measures. Why is the employee being fined less than the employer just because he has less money than the employer? Secondly, for 59I, there are about 100 sections. It is only when it comes to this section that employees need to bear a little bit of responsibility here. So this is almost the only section where the employee has to bear some liability. Then my question is, why is it only in this particular clause where the employees take up responsibility that they are fined less than the employer? Because when we have deterrent effects, if we want to send deterrent effects, we want to send that deterrent effects to all, including to the employees. Many employees, most employees are compliant, but there are some who are not. So my question is, Chairman, why is the occupational safety and occupational health legislation and the factories and industrial undertakings ordinance are discussed at the same time today? It is because this is about the legislative intent and they should be consistent. There's another point. Even though the ordinance is drafted this way, have you ever thought why there were no difference between the fines of the employer and the employee? It may be because that the contractor and the employee were one of the same. They are self-employed contractors. For example, I am a contractor that goes to the construction site to change some light bulbs. I may be the employee as well as the contractor. And what about households? The contractor may well be the employee himself. So does he go schizophrenic? Is he subject to level 5 and level 6 penalties at the same time? So there are these small contractors as well. Consider them. Yes. Concerning the question put up just now, concerning schools, if it is 59I, it is a school campus under construction. It's not about schools that are in operation, so don't confuse the two. Secondly, concerning the gravity or seriousness of the offense, where there are construction accidents, it is the employee, the worker, who is injured or meets with fatality. The reason why the employers have to be fined more, well, under the seriousness clause test, it is higher for the employers compared to the employees. And it is indeed true that they are more financially endowed, these employers, compared to the employees. So remember, there may be certain workplace injuries, and the employee meets with fatality, and usually in such scenarios would this section be used. And if you want to put them into the same level of penalty, that is not right. I, of course, want there to be zero industrial accident. But on the other hand, if you want to compare the levels of fines, you may have to calculate the value of a life as well. And this is the reason why there is a difference in the two fines. Now, as for small works, for example, in a household, changing a light bulb, or it is a downstairs corner shop, electrical shop, and the person may be an employer and the person changing the light bulb at the same time, then at this time, if he's a shopkeeper, then he is the employer. He is just carrying out the work himself, but he is an employer. So we have to be clear in our line. And I do not agree that he is an employer and employee, but he is not an employee. He is not protected by the labor ordinance. So he is actually an employer, and he is conducting that work in that identity. I disagree, Chair. If you look at the definition of worker, 59I, for 59I, it is anybody who carries out such work. Worker under 59I, it carries a special definition. It is not just any employee. And if you look at 59I, it says it covers all construction sites. So 59I is a very important clause which applies to all construction sites, big or small. Let me just supplement, Chair. We're talking about the highest penalty or fine. Under common law principle, the court will consider the financial sustainability of the accused. If it is a very, very small company which is found guilty, and the court in determining the fine level will consider the financial capability of the company. So it addresses the question just now as to whether a small company would be fined a lot of money. So that's for your consideration. And secondly, for construction site clauses or sections, there is a principle which is consistent, and that is, just now, the Secretary in the beginning had mentioned that in considering the adjustment of the fines this time, we have a overriding principle, and that is what is various serious and light offense. And we also categorized employer and employees. So we're not saying that this is about construction but rather, as long as there is a very serious offense, for example, then there will be 400,000 and 150,000 applicable to employers and employees respectively. So it is about the seriousness of the offense that we have determined the level of fine. Chair, follow-up question. Which part had he not answered your question? This is by extension. I'm asking a question by extension. The original 69, section 69, was it not like this? So what are you talking about? Way back in time or when? I don't know, Chairman. I'm talking about the section as it stands now, 69. Well, I think what she's trying to ask in terms of a question is that why was the original 69 the same in terms of fines for employer-employee? Well, just now, my colleague had already answered the question, and in previous meetings as well. He said that the 100,000 dollar fine is applicable to employers and 50,000 to employees. And my colleague had already provided the answer. Chair, I still don't understand. Just now, Ms. Kong had mentioned that there are small employers as well. So can the government, I don't understand their response or their answer, but can they in black and white explain the size of the works? For example, many developments and estates for residential estates would have these major repairs and maintenance works. And if there are some, let's say, demolition work and there are some subcontractors, who is the employer, please, in such scenario? And what about school maintenance and repairs or performance stage repairs? Well, there are some construction or reconstruction as well. So what are large construction works, and how do you demarcate small construction works? Where is the line? Secondly, about seriousness. Just now, the administration said where there are injuries or unfortunately fatalities, if that constitutes the test of seriousness, then it's problematic because this law is about deterrent effect. We do not want to see such incidents. You don't have to wait till injuries or fatalities before you activate seriousness or serious offense. What about the MTR incident yesterday? It was only lucky that it was not at the peak hour of traffic and therefore there was no major incident. Now, first of all, on the subcontractor or the contractor situation. First of all, on contractor size, under the ordinance, there is no demarcation of what is large or small contractor. But in the court findings, in the consideration of the court in determining the fine according to common law principles, there will be a suitable level of fine. There is no demarcation or distinction between large or small contractor in this ordinance. Now, as for seriousness of effect, my previous answer was when do we activate indictment and when summary prosecution. And my answer was where there is a serious incident with a serious consequence, then we will be following indictable route. So that was my answer. It was in relation to a specific scenario. Chair, I still don't hear the line between seriousness. What is serious and what is not serious? Give me the line that they adopt. Well, thank you, Chair. Thank you for the question. So now I understand your question. So you're not talking about indictable scenario, but rather what is serious, very serious, or light. In our following discussion, for each of the sections, we consider this. If you don't mind, actually, later on when we carry on our discussion, you would know why each section is considered very serious or serious, etc. So I think you will get more details when we come to discussions. Yes. So Clause 30. For Clause 30, it refers to Section 70(2). For qualified inspectors or qualified persons, if there is any contravention of Section 70(2), the fine is lowered to $150,000 from $200,000. The imprisonment terms is the same. And also it is being updated, but the content of the section is not changed. So this is in page 55 of your Appendix 1. Thank you, Chair. For 70(2), it refers to false reports or false certificates. And I think that this is very serious. The highest penalty in existence is $200,000. And the authority, the administration, is saying that the seriousness level of this contravention is not adjusted. It is not changed. But if that is the case, why is the penalty, the fine, lowered to $150,000 from $200,000? I'm not saying that it should be increased to, say, $400,000. I'm not saying that, but I'm asking about the logic of why not having further deterrent effect. And I think using false certificate of report is important. It is a serious offense because a person is in the know that he's using such false reports. Why is a fine being lowered?
點咧？其實我哋就
Well, the qualified examiner is, in our view, an employee, and the maximum penalty for other offences for an employee is $150,000. So we want to align it with other penalties. But for this particular offence, that is a false and materially false or incorrect report. Well, the maximum penalty does carry a prison imprisonment penalty of 12 months. How many cases were there that the department invoked this particular section to prosecute? Or that there were many cases that just want to maintain a good deterrent? Well, you may as well keep it at $200,000, or you can reduce it to $150,000. So I want to know the rationale. You have a framework, you have different offences with different penalties, and this is actually an exercise to align the different penalties. But you're sending out a wrong message then, that this is not really very serious. So my question is about how many cases there were. And if we have such a case, would you also consider prosecuting under other provisions such as preferring a false document? We did have this case, past case, as you can see in the table. From 2017 to 2022, you can see in the table that there was no prosecution invoking this particular regulation. Apart from the occupational safety and occupational health laws, apart from the factory and industrial undertaking ordinance and laws administered related to this exercise, there are other laws which the police can invoke. Well, this is not just aligning different penalty levels. You can align it with something more serious. But here you are sending out the wrong message that using a false document is not very serious. Well, what we have in mind is to achieve consistency. As I've said, for an employee, the maximum penalty is $150,000, and we want to make sure that the different offences carry the consistent penalties. We don't think this will send out a wrong message, because the maximum imprisonment term for this offence remains as 12 months. Mr. Doreen Comm. With regard to 59I, how serious would the case be? Regulation 70 mentioned to 35, 35F, 38F, 39.3. When are we going to seek such reports? These examiner qualified cranes, scaffolding. Well, I'm not an engineer. If excavation, crane operation, and scaffolding can be risky, and we need someone to inspect and examine the equipment. Because if you do not examine the equipment properly, you are putting workers at risk. For 71, it's a level 5. And that is failure to do the examination or submit a report. That is the competent examiner fails or does not submit a report, then the penalty is level 5, $50,000. But for 72, well, they may be. It's about providing false information, and you are reducing the penalty here for regulation 70. So if failure to submit a certificate will carry the same penalty. But if a materially false report or certificate is submitted, the penalty is reduced. So what's the logic? First, of course, about the seriousness of the offense. Ask the chief occupational safety officer to say something about how we think that seriousness is different. For construction safety offenses, we regard these offenses as very serious. As for the downward adjustment of the fine, we want to achieve, as explained, consistency concerning of the fines that can be imposed on an employee. But we still regard this as a very serious offense. As for the two regulations referred to by the member and why do we think they are different in seriousness, I'll ask the chief occupational safety officer to explain. Well, there are two different levels here. Well, we have to consider the two relevant procedures, examination, and then after the examination is done, a certificate, a report has to be submitted. So whether the examination has been done is is the first consideration. Failure to do the examination, well, it's a serious offense. As for the second category, failure to submit the report in good time or something is missing from the report, that is an offense with a different level of seriousness. Mr. Lee Chen-Kang, I think prevention is always better than cure. We want to ensure that there's no industrial accident. For competent examiners and the companies offering competent examination service is doing an important job. Well, you know, metal fatigue is a very important situation because construction workers cannot find out whether there is such a defect. Only through the work of the competent examiner can we discover such defects. So it's very important because that would ensure we have good prevention of accidents. That's why construction sites have safety officers. You have explained the reason why you want to reduce the fine from 200,000 to 150,000. But from this, I just don't see how you can say that what you want to achieve is to prevent accidents. Who are these competent examiner? And we are talking about the firms offering such examination services. Sometimes the certificate or report is not signed by an individual examiner, but by the firm offering the service. So, how are you going to deal with the offences in respect of false reporting? Well, with regard the submission of a false report is a very serious offence. Or you think that by adjusting the fine levels, well, we are saying that it's not a serious offence. We still think it's a serious offence. Well, for this particular amendment exercise, most fines are adjusted upwards on the whole. We are doing an upward adjustment exercise, but for some, we want to do things in a consistent manner. As for the certificate issued by a examination agency or firm, the report is still signed by an individual examiner. In other words, the competent firm employing the competent examiners cannot be held responsible. But if you want to maintain consistency, why can't you increase the penalties, the fine levels? Well, there are different offences, many different offences in these laws. And how do we tell people that we think some are serious, some are minor? Well, so we are adjusting the fines generally in the direction of increasing the fines. As for the examinations certificate issued by a firm, it's signed by an individual. We are not just trying to change the structure of the law. We're just adjusting the fines in accordance with the level of seriousness of the offense. Mr. Tony Chair, well, usually when we amend these laws, we are in effect talking about generally the levels of fines. And now you have a new categorization system. There are 3 levels. We have already spoken for more than an hour now. Many members have questions, and I think the important thing is to look at the principle, how different offences are categorized in relation to seriousness. I think the government should come up with something consistent that would save a lot of the time. Either or this explanation can be offered either verbally or in writing. That would save a lot of time for members to raise similar questions. And there are questions about why there are different fines imposed on employers vis-a-vis employees. Well, I think there are some principles behind that. But I think we should elaborate and explain the principle first. The important thing is to maintain consistency. Otherwise, we can always argue about the exact fines. If you say 150,000, then why not 120,000 or some other amount? I don't know whether it's because the administration consider that the contractor and the employees do have a different power or authority over something that has been done. Because if something goes wrong, the workers will be affected most. And the question is whether this is done knowingly. For example, if you are an electrician and you do something deliberate that would put your life at risk, then the chances of an employee doing this would be lower.
雇員
So an employee or an employer, you can call it the worker or the contractor. I think they have a very different sets of circumstance. And that is why I think it was said that the reason was the supported the lowering of the fines and in certain situations revision upwards of the fines. I think the chairman is correct in saying that, first of all, the principles have to be consistent. And then if members have different opinions, we can raise them for specifics. And I really want the clause-by-clause process to go with efficiency. Chair, I think Mr. Tse's point is very much the same as ours in our thinking. In each of the sections, we will refer to their seriousness, whether they're very serious, or minor. And then we will, in looking at the fines, as mentioned, very serious, and minor, those are the three levels. That is the principle of our determining the level of the fine. Yes, my colleague will supplement. Yes, that's right. When it comes to further deliberation of each of the sections, we can discuss why each is considered very serious or minor. And overall, the principle is that what is minor offense in principle that's causing minor effects or consequences and causing medium harm or minor harm. For example, not posting up relevant notices, these would be minor. But what would be serious offense? That would cause serious or medium level consequences. For example, not providing exhaust mechanisms for certain machinery. And for various serious, it would be offenses causing serious or very serious consequences, which may cause bodily injuries or fatality, such as high-level work contraventions or offenses, etc. So this is the high-level principles of determining the levels of seriousness and therefore the level of the fines. And in discussing each of the sections, we can discuss the specifics of each of the offenses mentioned in the sections. Look, Harman. Declaration of interest. My company is in the property and construction business. Now, concerning the principles of this ordinance, of this particular section, false reports or certifications. For these false reports and certificates, the offense is very serious. Now, even though the imprisonment terms is 12 months, it is left the same. But on the other hand, the fine is drastically lowered. Yes, as the Deputy Secretary had mentioned, some increase the fine, some are increased, in some occasions it is decreased. But on the other hand, they are consistent. Actually, I don't understand what he was saying when he said that. But here, we're talking about a serious offense. Now, in the afternoon, there was a mirror report discussion. And in the discussion, it is found that it is because of false reports and false representations that they have caused the mirror accident incident. But here, on the other hand, with false certification and reporting, the fine is being lowered. Why is that? I want to ask the government, what kind of message are you trying to send to the employers, employees, and society in the seriousness of this kind of offense by lowering the fine? What kind of a message do you intend to send to the public? Thank you, Chair, for the question. As mentioned just now, we think that offense against this ordinance is very serious, and therefore it is $150,000 in terms of fine. Lowering the fine, on the other hand, it is because of consistency of adjustment. That is the reason. But the imprisonment terms remains the same, which is 12 months. And we do see this violation as a serious violation. The fine had been lowered because in the overall adjustments, amendments, we wanted to be consistent. Chair, you've heard the administration for so long. They seem to have a very strange logic. We have heard the response many times. They want to be consistent, quote unquote. They want to purely be consistent, quote unquote, they say. But this is not for administrative convenience. I mean, for the construction sites employers or employees, we want them to be safe. It is not for administrative convenience or simply for consistency. That should not be the case. Chair, you should be fair. I mean, you just, the administration just mentioned this is just for consistency, and some are adjusted higher or lower for that reason. They say, quote unquote, just for consistency. But I don't understand the logic. Yes, I will help follow up with this question. This $200,000, which was a previous level of the fine, is it because it was not so clear before with the three levels of very serious, serious, and minor, and therefore there had been some adjustment needed to adjust it to 150,000 now? I mean, is it because it was not consistent before? Let's leave aside, administrative convenience, but rather was it not consistent before and you're making it consistent now and adjusting it down to $150,000? Well, Chair, actually, we have followed the demarcation of levels of seriousness in setting the fines level. Different levels of seriousness would attract different levels of fines, and different offenses will have different levels of seriousness. And therefore, we have come up with these three levels of seriousness to provide some consistency. I just want to reiterate just one point, and this offense is a very serious offense. It is not that the administration thinks that this is a less serious offense now compared to before. All right. Xiu Ka-fei, first round. Xiu Ka-fei. Chair. Still on this point about false report being sent to the contractor, the fine is being lowered from 200,000 to 150,000. And from the mirror incident, we see that it is a contractor making false representation. They have lowered the numbers for load, etc., so that they want to be able to organize the event, the concert. Well, just to remind members, do not talk about the details of an other case. Chair, I'm just repeating what the government said in the case. I'm just repeating the government's findings. The government had just published the findings concerning the mirror case. For preliminary investigations, the contractor is misrepresenting, misreporting the weight and load of certain equipment and therefore had caused this accident. And we see the results being very grave. Now, the fine is being lowered from $200,000 to $150,000. The public will get the impression that it is not a positive message in protecting against industrial incidents. Now, the members seem to be in agreement in opposing this lowering of the fine. Are you going to retract? Is the administration going to retract the level of the fine? Chair, I just want to say that this is not applicable to the incident mentioned by the member just now. This is not a situation that he had mentioned, but rather it is a construction site situation. These are very different. These are incidents of very different nature. Please be clear in your comparisons, trying to compare the different scenarios. Do not put the other scenario into the applicable realm of this particular ordinance. All right, Chair. What about false representation? If there should be any false representation or false reports, what would or something like the concert situation, the mirror concert situation, where would it come up under this ordinance? Chair, for specific sites ordinance, the specific sites ordinance would apply. This is about construction sites here, what we are dealing with here. For others, there can be other ordinances such as in general responsibility sections in other ordinances. And yes, we're looking at that as well. Chair, just a point of supplement. Even if this ordinance does not cover the concert site scenario, but only construction site scenario, even so, I oppose to lowering the fine level for misrepresentation or false reporting. I will object to lowering from $200,000 to $150,000 as proposed. So, concerning Section 30, we have, that is 70(2). We have spoken, members have spoken. The administration had given an answer. I still do not understand the consideration. If it is just to be consistent, I think that is not ideal. And in sending out a message to the public concerning an ordinance, once there is an offense, what is a message we want to send out? Well, I'm looking at 35(1) and 35(3). Section 35(1) and 35(3). It says, if the person is not qualified to carry out the investigation and the inspection, such as in a crane situation, it goes on to say, if you read that in conjunction with 72, then it is about an unqualified person in inspecting the crane. And then after that, there is a false report given out. Now, in this kind of a scenario, the administration is proposing doubling the fine from $200,000 to $400,000. So this is a false report. But coming back to here, 70(2), it is lowering the fine from $200,000 to $150,000, lowering it, not increasing it. I'm very much in agreement with Mr. Dare, the Honourable Mr. Dare's point. I mean, going forward, if we have a few hundred sections to go through, there would be many such situations where there will be cross-referencing among sections. And for some of the fines levels, they are raised so significantly, like doubling in certain instances and lowering in other circumstances, then I think we need some examples for our reference. And if the administration can provide examples or case studies, then it would help expedite the discussion process. Yes, Chair. For such behavior, it is a very serious offense. And $400,000 is a fine level that matches very serious offenses. And I don't think it is different. $150,000 here is also very serious offense, and they are therefore consistent. Chair, I think for certain accidents or incidents happening, it may not be for a single reason. It can be a series of reasons, including the employees and employers. They may have to both bear certain responsibilities. That is true. But it is possible that the employee, the inspector, had given out a false report, and he may be even providing false information to the employer as well. Even if the employer had done a lot of things, but the employer had not prevented this from happening, and too bad for the employer. So the employer still have to pay $400,000 and the employee $200,000. Is that what you're saying? Chair, it's very difficult to answer hypothetical questions like this.
Well, it's up to the court to assign the responsibility shared by the party, and to consider whether the maximum penalty should be imposed. I'm not asking a hypothetical question. I'm seeking some information here. I noticed that on the right-hand side, we are told the number of conviction or the summonses resulting in conviction from 2017 to 2021, and there's none. For this particular offense, there's none. Well, you're talking about conviction, but what about prosecution? Has there been no prosecution, or just no? You are just talking about no conviction. Assistant Commissioner, well, we are talking about zero conviction. As for whether there was no prosecution, if you want to know this piece of information, we need to dig out the information. That will take some time. Perhaps you can give us the information in writing after meeting. I want to know whether there was no prosecution and on top of no conviction. And I want to talk about 70, Regulation 70, bracket 2. The examiner or person knows is false. That's how it's worded. It's in this Regulation 70, bracket 2. As some members have said, this is a serious offense because false information may lead to a serious accident. Sometimes for similar offenses, you're not just saying that this is done knowingly. There may be reasonable doubt, reasonable belief, etc. If you say they knowingly commit this, well, it can the prosecution would fail very easily. How do you know this is done knowingly? And secondly, examination is very important. We're not keeping the level of fine. I know you have some principle to follow. for that's not just for regulation 59I. 59 is the same. 59O for cargo lifts. There's a bigger reduction. That is a force representation. It's reduced from 200,000 and 12 months of imprisonment to $50,000 in fine and 12 months of imprisonment. I don't understand why you don't keep the fine level. Instead, we are going to see a big reduction. It's a bigger reduction for lifts. Well, actually, we already have had the same discussion in respect of the last clause. We're saying that there are different parties shouldering different responsibility. Some examination are carried out by the contractors and some are not. On the whole, the fines go up, will go up. Actually, we spent a lot of time in the last 4-hour meeting. What about knowingly? The standard of knowingly. Assistant Commissioner, thank you. Actually, we are repeating the same point here. We are adjusting the fine only. We are not changing the relevant standards, and we will seriously deal with these issues in the next exercise. As for the reduction, it's more for lifting appliances. We would offer an explanation when we proceed to those clauses. So the standard of doing something knowingly will be reviewed next time. Clause 31. Please refer to pages 55 and 56. And that is Regulation 71 to be amended. 31(1), 31(2), amending Regulation 71/21. The fine will be amended. Any person who contravenes Regulation 48(2) commits an offense is liable on conviction to a fine of level 5, 150,000. And 31(2), and the fine will be reduced. Anyone who contravenes Regulation 48(2), the fine will increase from level 3 to level 5, $50,000. And 31(3), anyone who contravenes Regulation 53(1) or 54(2), the fine will be increased from level 3 to $150,000. All right, then we can move on to clause 32. Thank you. Clause 32. Well, I could barely catch up. 31 or 32? What do you want to ask? Well, he covered both clause 31, bracket 2 and bracket 3. I want to ask a question about 31, bracket 3, and that is Regulation 54, bracket 2. No one should do anything to affect the fire escape or the fire safety equipment. And for 50 bracket 1, the penalty is bracket 1. The penalty is 50,000 to 40,000. For this one that we are talking about here is 10,000 to 150,000. What's the rationale? We're talking about the responsibility to be borne by an employer vis-a-vis an employee. For 50 bracket 1, it's the employer's responsibility to maintain a clear fire escape. For 54 bracket 2, it is about the responsibility of an individual. So it's set at $150,000. It's just go back to the same issue. For an employer, the maximum fine is $400,000. For an employee, it's $150,000. So are you talking about this principle? Well, this is a consistent principle we apply. All right, clause 32. Please go to page 57 all the way to page 71. Clause 32, amending Regulation 19, and the fine will be revised. Violation of 7C or 8, the penalty would increase from $50,000 to $400,000. Violation of an offense 4, 5, 6A, 7B, 7C, 7D, 7E, 1, 7G, bracket 2, 7H, 7I, 7J, bracket 1, bracket 2, or bracket 3, 9, bracket 1, or bracket 2, 12, 13, 15, 15B, bracket 1, or bracket 3, 18, bracket 1, bracket small a, bracket small c, bracket small d, small eb, bracket h or bracket I, or 18 capital A bracket B, or 18B, the fine will increase from $200,000 to $400,000. Violation of 10, 11, 12A, 14.1, bracket A1 or bracket 2, 15B, bracket 2, 15C, 16, bracket 1, bracket 2, bracket 4, or 5, or 17. The proposed fine will go up from $50,000 to level 6, that is $150,000. Violation contravention 7A, 7E, bracket 5, bracket EA, or bracket G, or 18A. The fine would go down from $200,000 to $150,000. Violation of 18C, bracket 2, bracket C, or bracket 5. The fine will adjust downward to $25,000. Here we are talking about the factory and industrial undertakings, lifting appliances and lifting gear regulation. And that is about the safety in using lifting appliance or gear in a factory, and the fire safety and the industrial safety issues. Clause 32. We are talking about quite a number of regulations. I'm concerned about 5. That is 57. And also page 64. 7 bracket A. The two are related. The original fine $200,000. One would go up to $400,000. The other will be reduced to $100,000. And 7A. And there have been past cases. 79, 46 cases in the past. Well, you need to have at least one examination by a competent examiners in the previous 12-month period. Failing that, no examination by a competent examiner. The fine will be will be increased to $400,000. But for the other offense, 7 bracket A, and that is inspection weekly by a competent examiner, the fine will will be reduced from $200,000 to $100,000. I think the reason offer is not reasonable. You have to do an examination every 12 months, and if the week where the gear is to be used, and there's been no examination, you don't know whether something bad happened the previous day. So failure to do this will be just the same with the case of failing to do an examination in the past 12 months. So why do you want to increase the fine for one to 400,000 and reduce it, and not the other to 100,000?
動機之前，
Especially within the week, if you're going to use the lifting gear, you have to be sure that it's safe, rather than to say that within the past 12 months there is the safety certificate and I can just glance at it. So usage within 1 week, I think it can cause very grave consequence. Well, thank you for the question, Chair. Now, this question is the same as the one asked by Mr. Lo Wai Kwok, or similar to his question about lifting gear. And the occupational safety officer, in this regard, he has further information to provide. Yes, we can consider Section 5. Basically, it's about a qualified and competent examiner to have conducted detailed inspection on the structure of the lifting gear, the testing, the safety of the lifting gear. The only difference is that for 7A, for these competent and qualified examiner, for their weekly examination of these lifting gear, and we know that inspection or examination can involve visual inspection as well as some very simple testing. Now, on the other hand, if such examiners are not retained to do such work, the possible consequence can be varied. And therefore, for this competent examiner, for the highest level of penalty for these two sections is because of the difference in the possible consequence of the offenses. Chair, 7A, the highest level of fine is $200,000 lower to $150,000. And again, this is for consistency, quote-unquote, reasons. The message, again, is the wrong message being sent out. Mr. Ho, I think we have to look at this in conjunction with Section 5, Chair. That is, we have increased the fine to $400,000 from $200,000. So who should bear the higher fine? The engineer concerned or the examiner who conducts a visual inspection? Well, we think they're both important. For the second section, we have increased the fine to $400,000. Yes, my colleague will supplement. Yes. The member's point was correct. We're talking about Section 32 and also 7A of the ordinance. This is not for consistency. Of course, they should be consistent. They are consistent. But also we have considered the seriousness, as the Secretary had pointed out. The seriousness is a very serious level. And therefore, the fine, we propose to adjust it as propose, lowering it. Now, the fines are being adjusted upwards and downwards, and we have heard the so-called consistency put forward by the administration in Section 7. So are you saying that the fine level of $200,000 will never appear again? So it's going to be either $150,000 or $400,000. Is that true? Mr. Ho. Well, Chair, as mentioned, Yes, the three levels for the employee should be $10,000, $50,000, and $100,000. And for the employer, it is $25,000, $100,000, and $400,000. Right, Chair. We want there to be safe operation of the lifting gear, but I see that the fine is being lowered to $100,000, and for scaffolding and cranes or lifting gear, it's been increased. The fine been increased from $100,000 to $200,000. Why is this being downward adjusted now? Yes, if you look at Section 5. Section 5 are really qualified professionals carrying out the examination or inspection. As Mr. Lee had mentioned, these weekly examinations is one thing, but on the other hand, a regular examination is not as important as a professional person's examination. So we have increased it to $400,000. As for weekly visual examination, I just want to point out $100,000 is still a serious offense. It is not an unserious offense. Paul Ming Lai. Thank you, Chair. The administration, in answering our questions, elicited a thought in me. And I would want the administration to explain the logic of it. Now, we think that prevention is very important and deterrent effect for the employers and the employees or the contractors or workers important so as to raise their awareness of such possibilities of incidents. Now, just now, I heard the explanation concerning 32C, and these are examinations, fine being raised from $20,000 to $25,000. Prevention is better than the cure, of course, we know. And for construction design, etc., safety should be taken into account. So shouldn't we be more stringent in these areas? And now you seem to be sending out a message to the public that prevention is not important. You're saying that it is a serious offense, but on the other hand, you're lowering the fine from $200,000 to $100,000 and from $50,000 to $25,000 respectively. That's a message you are sending to the public. What kind of a message is it? Chair, I will start answering the question and Mr. Chan will supplement. Well, I've actually said this before in answer to members. Look at 5 and 7A together. They're both about maintenance. One, we have raised it to $400,000. Don't just look at one side. The other side, we have raised the fine significantly because this may cause serious injury or fatality. Which one is more serious? An inspection of lift, if there is shoddy inspection causing injuries, or is it someone who had carried out weekly inspection? Which one would cause more serious incidents? Well, you see that it is $400,000 plus $100,000 now. So that's $500,000 in total. So the message is very clear. For professionals carrying out an examination as opposed to the worker on the construction site carrying out weekly inspection, they're both serious, but the responsibility level are different. Yes, let me thank the question. Prevention, of course, is very important. And for weekly examination or inspection or 6-month inspection, these are preventive measures. So preventive measures are important, but the seriousness is different. Why? because for inspection and examination, they are carried out by different people. Here, one is a professional, and the relevant depth and breadth of inspection are also different. So that is why for the 6-month qualified examiner examination is very serious. And contrastly, the weekly inspection or examination is still serious, but compared to the professional examination, it is not the most serious. And therefore, I hope this answers your question. Please be succinct. We need to end this meeting at 10:30. Yes, so please be succinct in your questions. Second round. Mr. Chen. Yes, 7G bracket 2, page 72 in your chart. So this is about cranes and lifting gear in a special weather situation, and there should be a qualified examiner who should look into the equipment concerned. Now, the fine is being raised to $400,000, but there were no summonses or incidents in the past. I think this is subjective. Can you talk about the case? How does one, as soon as possible, carry out the examination, and what is the kind of weather condition you're talking about? Is there any reference you can provide to the industry? Yes, the safety officer. Well, actually, if you look at 7G bracket 2, first of all, it is a lifting gear being exposed to bad weather such as typhoons or strong winds. And the lifting gear or crane itself is under external force and its stability is being affected. Then the contractor, upon discovering that there is any doubt to the stability of the crane, then a qualified examiner should be asked to carry out the examination. And only under safe circumstance can workers use this crane or lifting gear. So, Chair, in an actual situation, if the crane had been exposed to bad weather, actually even before use, there should be assurance that the equipment is safe. And you say here that it is to be examined before use of the lifting gear, and you say as soon as possible, but that is uncertain. It is unclear. And maybe this was wording that was used before. For this round of your amendment, it is just the level of fine that you're adjusting. So perhaps you can make this wording more clear if you can go back rather than to let people fall foul of this clause. Yes, we hear the comment, and we will go back and look at it, and where necessary, we will consult the industry. All right, let's go to Section 33, or Clause 33. It's now 10:30 almost, and there is a welfare panel, the policy briefing for that, and I'm sure members who are interested will be going over to the other room. So we close the meeting here. Thank you.